Welcome, everyone. Welcome to today's webinar. If you don't know me, my name is Connor Spencer, and today we're going to be discussing navigating the new employment and contractor laws with confidence. We will also be sharing a special offer to those of you who are attending today's webinar. As some of you may or most likely will be aware of, that there's going to be a number of changes in legislation coming into effect on the 26th of August. So literally next Monday, hence the timing of this webinar. So we do know every single year when these changes do get made, a lot of our existing and new subscribers will be clamoring to book in those consultations. So I would recommend that, yeah, get ahead of the curve there and get that advice for your business as soon as possible. But today's webinar is to obviously give you a bit of a foundational understanding of what to be aware of when it comes to those new contractor and employment laws. It is obviously just foundational and to provide some insights. There is crossover from business to business, but you will need specific tailored advice just for yours. And that can be dependent on where you're at in your business journey, what industry you're in, what state you're in, or any specific short-term or long-term goals you have. We will be sharing an email later today with the slides and recordings for those of you who are present. However, obviously, to start that conversation about protecting your business and doing things right in your business, you can let us know in the webinar chat. We can reach out to you via that or via the email to get you started. But for those of you who are new to LawPath, I think I need to skip a slide. For those of you who are new to LawPath, okay, who are we? Who are we to even provide you this content in the first place? We are an Australian-based online digital legal platform. We also provide accounting and tax advice online. And we've been operating for a good part of 10 years now and helped over 500,000 small to medium businesses register and begin that journey. We supply over 500 legal documents with a contract management system. These documents are fully customizable. That comes with a contract builder as well. So depending on your inputs, we'll adapt the contract and provide you with that legal floor of the business. And also, very importantly here, we also provide legal consultation. So it's a really unique subscription service that we've provided. We've got close to 15,000 business owners who are actively using our essentials or advice plan. So it's incredible value for money to quickly be able to understand your legal position, simplify the legal jargon, and always be engaging in good business practice. And you can do that for the same reason you're on this webinar, by being proactive to the legal aspects of your business and not just reactive. But what we'll be discussing, there's a whole host of legal and accounting topics that we give advice on. For today, we're going to be looking at and covering the contractor versus employee, those current definitions, new legislation overview, and tax obligations. And then, as always, we'll finish with how LawPath can help. We're actually going to throw in a product demo as well today. And then we'll also finish on the Q&A with a special offer. But running through the agenda today, we have Damon. Damon is LawPath's principal lawyer. You'll see, for example, Damon has a 5 out of 5 star rating at over 300 reviews on our Meet the Lawyers page. He has advised on capital raising transactions valued in excess of 600 million and has acted on behalf of over 2,000 startups. We're also fortunate to be joined by Tim Quinn. Tim Quinn, he's a qualified chartered accountant with 17 years of professional experience in tax and business advisory at all stages of their business life cycle from startup to exit. And he has run tax divisions at director's level. But I'll hand things over to Damon first, and we'll jump right in.
Thank you very much, Connor. Hello, everybody.
Yes.
Let me see if there we go. All right, so we're going to look at the beginning at just basic, what is an employee, what is a contractor, what are the main terms that you should have in that, and then we'll jump over to some of the new amendments to the law, which might be relevant to you. So generally speaking, if you look at an employment contract, a lot of times people will hire a casual, and they'll say, well, we don't need an employment contract because they might be under a modern award. And if you guys don't know what a modern award is, it's essentially the minimum standards of employment based on a particular industry. So manufacturing has the manufacturing award, retail has the retail award, and that's what sets out your penalty rates, your overtime rates, minimum shifts, allowances for meals, things like that. So a lot of times where you hire a casual, people say, well, I don't need an employment contract because that's all, everything's covered in the modern award. Or people might say, I don't need an employment contract because, the Fair Work Act covers everything. But there's a lot of things that an employment contract covers that isn't in the modern award or that is not in the Fair Work Act. And those things primarily relate to what's the job title, what's the description. You want to make it specific whilst at the same time having some broad areas so that you do have the flexibility to change someone's role and responsibilities. If you don't have a clause that allows you to change their roles and responsibilities, and you do so anyway, it could be what's called constructive dismissal. By you changing someone's salary, by you changing the hours that they work, by you changing the location of where they're working, or anything like that, that can be deemed as a termination at the initiative of the employer, which can trigger an unfair dismissal claim against you. So you do want to be fairly clear in what the job title is, what the description is, and you want to have a non-solicitation clause in most circumstances. So a non-solicitation clause says you're not going to start up a competitive business or move over to a competitive business and solicit away any of our employees, our suppliers, our contractors, or our clients and customers. And if you do, then one, we can go get an injunction against you to stop you from doing that, or two, we can sue you for damages. And that, unfortunately, a lot of times people don't have that clause in their contract, and that clause is only enforceable if you actually have it. There's not a lot that you can rely upon where someone goes and steals all your customers and employees unless you have a non-solicitation clause. You can fall back on a confidentiality clause or an intellectual property clause, but generally speaking, that won't be nearly as protective as a non-solicitation clause. Termination clauses as well. A lot of times people will just say, if either party wants to terminate, you'll give 4 weeks notice. The problem is that you might hire someone, they might be in their probation period. You might have determined within the first 3 weeks that they aren't going to be the right fit and you want to terminate them. But if you have a 4-week termination clause, you're stuck with having to pay them out 4 weeks or making them work out those 4 weeks when you actually just want to get rid of them. So normally you would say that during the probation period of 3 or 6 months, either party can give 1 week's notice, and thereafter it's 4 weeks, for instance. And then confidentiality, you want a confidentiality clause and an intellectual property clause that says that any new ideas, new inventions, anything that's developed by the employee is owned by the employer. And then if you look at restraint of trade clauses, that's for your senior representatives. So if you have a senior sales position or a senior CTO technology officer position, then you're probably wanting to restrain them from working at a competitive business for a period of time. And then finally, you want to have clauses dealing with the fact that your employee has to comply with your policies and procedures. Normally, your policies and procedures do not form part of your employment contract because your employment contract is stagnant. It's once it's signed, that's it. It's not easy to amend. Whereas your clauses or your policies and procedures might adapt from time to time. So they don't form part of your contract. Instead, you just have a clause that says that your employee will comply with those clauses. Another thing that just to note is if you put in the employment contract that they're going to work from home, that means that you can't bring them into the workforce ever again or into your workplace because the contract specifically says work from home. So a better way to do that is say they have to work from your office if you have one, or from the office if or when you do get one. But for the time being, they can work from home in accordance with the work from home policy. And at the moment, your work from home policy might be 2 days a week or 3 days a week. But if you ever wanted to retreat on that and make them come and work in the office 5 days a week, then you would just amend your work from home policy, give them a sufficient time and notice of the change, and then you can force them to come back into the office. Now, there is a significant difference between an employee and a contractor. So, for instance, as an employee, all intellectual property that's created by them is automatically owned by the employer. And for confidentiality, they're automatically bound by confidentiality. However, with a contractor, it's significantly different in that anything that's created by a contractor is owned by the contractor. And there's not generally an implied duty of confidentiality unless you have that specific clause. So I'll just get Connor to move to the next slide. And we will deal with contractors, I believe. Yeah, so we'll just go next. Now, with a contractor, if you don't have an intellectual property clause, it's all owned by the contractor. So if you ever had someone come and do work for you, you had a contractor's agreement, or you didn't have a contract at all, but they invoiced you for the work, anything that they've created is automatically owned by you. There's no law that automatically assigns or transfers intellectual property over to the other party unless it's in writing. So that's first off, that's significantly different and important to understand. The next thing is, even if you draft up an employment or a contractor's agreement, it doesn't necessarily mean they're a contractor from a legal perspective. And that's because to be an actual contractor, there's certain elements, there's about 16 that the courts will look at to determine whether they actually are a contractor as opposed to an employee. And those 16 elements are whether the contractor supplies their own goods, like their tools of trade, laptop computers, motor vehicle, mobile phone, whether they have the right to accept or refuse work, whether they have a right to outsource the work, so hire subcontractors, for instance, whether they're forced to wear uniforms, whether they have to comply with certain policies and procedures. And these are all factors to consider whether you're a contractor or employee. But generally speaking, if you use your own tools, your own car, your own mobile phone, your own laptop computer, if you don't have to wear the principal's uniform, if you can choose to accept or turn down a particular job, if you're allowed to subcontract the work, and if you're invoicing for the work, then you're more likely to be a contractor. However, we have the gig economy issues now, and as of the 24th of August, so next or later this week, new laws are coming in regarding what they call employee-like relationships. And this is what we've seen in Uber and other marketplace arrangements. And there has been many cases in the past where they found contractors are actually employees. And the main features of that is whether they were forced to wear a uniform and whether they were able to run their own enterprise. So for instance, if you run a cleaning business and you hire a cleaner and you say that you're the one that's being hired and you can't outsource it to anybody, and you have to do the job and you have to wear a uniform when you're working in the building, then even though they're a contractor on paper, they're more likely to be found to be an employee because they can't run their own enterprise, which means run their own enterprise, meaning market their own business, hire their own staff. And those are the features that are considered. And if it is found that someone has been hired as a contractor, but they're in an employee-like role, then the tribunal, the Fair Work Commission, has the power, and the federal court has the power to overlook that contract and deem them an employee. And so if you decided to hire someone as a contractor rather than an employee to maybe overcome the modern award penalty rates and minimum shift requirements, then it could be found that you're actually in breach of the modern award, They then find them to be an employee, and then you get hit with having to pay them all the unpaid statutory entitlements and underpayment of wages. So it is very careful, or you got to be very careful if you are going to hire someone as a contractor. If they're really in an employee-like role. The other thing to look at is from a legal perspective, if they are a contractor, like they can accept or take their jobs whenever they want to, or they're working on a specific project for a duration of time, or they're just consulting to you and they run their own business as well. That's the true nature of a contractor. But they can still be deemed an employee for tax purposes. So from a legal perspective, they can be a contractor and everything's fine with you paying them their invoice amount. But from a tax perspective, they could still be deemed an employee. And what we mean by that is that if a substantial or majority of their work is being done from one income source, so for instance, if you hire that contractor and the only other income, or they're not earning any other income from anywhere else, then generally speaking, the ATO doesn't necessarily trust small business is going to actually pay super and have enough money to pay their tax at the end of the year. So they can find that a contractor is deemed an employee for tax purposes and require the principal to withhold the tax and to pay super in those scenarios. Normally, it's where that contractor is just an ABN holder. And so it's important that if you do have a contractor's agreement, you want to say that if at any time the contractor is deemed an employee from a tax perspective, where superannuation is required to be paid or tax is required to be withheld, then these amounts will be what's called grossed up into the invoice amount so that you don't have to pay those the tax withholding and also the super on top of what that invoice amount is. Instead, you take that invoice amount and you subtract the two so that they're not getting any better off as a result of them now becoming a deemed employee for tax purposes. So it is a fairly complex area. Tim might touch upon this, and we can ask Tim later about these questions as well. Moving on to the next slide. Now, the obviously advantage of hiring a contractor is you get the flexibility. You don't have an unfair dismissal. If you were to terminate their contract, you just terminate them by notice. You don't have to pay any entitlements. A lot of times, if you had a startup, you can't actually afford an employee because you don't have enough work to pay an employee based on their award rate. So sometimes you might hire a contractor, and that contractor might just help you, for instance, an advisor, and that would be an appropriate situation to be hiring a contractor where it's a startup and it can't actually afford an employee. But that case at the below is the main case from many years ago that was talking about contractors being able to run their own enterprise and not wearing uniforms and being able to accept or reject particular jobs. So if you were to hire someone in your business as a contractor at the beginning because you're a startup and you can't afford an employee, you still got to be very careful of all these elements to make sure that that person is going to be a contractor and not an employee. The other thing is a lot of times we get it where people say, well, we're not going to pay this employee a salary because we're a startup, we don't have any money, so we're just going to give them shares in the business. That's not good enough. If you hire someone as an employee, you have to comply with the Moderate Award and the Fair Work Act, which means that you're actually paying wages, paying wages at a minimum monthly, and more likely than not every fortnight. Giving pay slips, withholding tax, paying super, accruing annual leave, long service leave, public holiday pay, and so on. And so if you're just paying them in shares, that doesn't qualify for any of those requirements, and you'll be in breach of all the elements of the Fair Work Act. And if that person was ever bringing you to court or to the tribunal, not only would they likely be able to keep their shares, on top of that, you could be liable for all their outstanding wages and entitlements. Next slide. So I think we kind of covered this. Is the problem with hiring a contractor is that you could be found to be a sham contract. That could be in an employee-like position where the contractor gets turned into effectively an employee. So you have all those risks. Other risks are that if you don't have a proper contract, the IP is owned by them. Confidentiality, if you don't have a clause, uh, they don't have any duty of confidentiality. Um, they don't have any duty not to steal your documents and so on unless you have clear documentation reflecting that. So for instance, under the Corporations Act, it says that a director or employee or officer of a company must not misuse the information and must not misuse documentation for the benefit of themselves or someone else. That doesn't apply to an independent contractor. So there's a law that you could rely upon for an employee if you didn't have an employment contract, but you can't rely upon it for a contractor. So these are the kind of risks of having that contractor position. The other thing is whether they have insurance. A lot of times you'll have a clause that says you have to have professional indemnity insurance or product liability insurance or something similar. But if your contract just says they have to have those insurances, but you actually never get a copy of the actual insurance certificate, then what happens if 2 years down the line you're sued and you say, oh, well, that was work done by the contractor. Let me contact the contractor and get a copy of their insurance policy. And you find out that they've been deregistered and they're gone, and you can't find them. Well, you don't have anyone to pass the blame. You don't have any insurance company that you can sue because you never got a copy of that insurance policy. So if you do hire a contractor, it's very important that you get insurance. You got to make sure they're covered for slip and fall, public liability, workers' compensation, professional indemnity insurance if they're selling your um, product liability insurance as well. And we'll move to the next slide. Now, looking at some of the newer changes, so um, there's been case after case after case talking about Uber and all the different ride shares and whether these people are properly being looked after as contractors, and they found that they're not. And essentially, they've been classified as contractors effectively to circumvent the award rates potentially. So they now have introduced the employee-like terms under the Fair Work Act. So it's much more serious if you breach it, and it's going to be more scrutinized now. So that's one of the things that are coming in next week, and that's why we were trying to hone that in so that you're aware of it. Next slide. The next one is the right to disconnect. So if you have employees and you're sending them emails after work, an employee has no obligation to respond to that email at all. They're allowed to turn off their mobile phones, turn off their emails, and they do not have to respond to you at all, and you can't make them respond. And if you do, and you're trying to make them respond after hours, then they can take you to the Fair Work Commission and and seek an order that you're not allowed to do it. And if you take any adverse action against them as a result of not responding, then in those circumstances, again, the employee can be in breach of the Fair Work Act. Obviously, there's a reasonableness test where there's something urgent that can excuse the employer, but generally speaking, that is one of the updates coming in next week. On top of that one, we have some more on the next slide, but on top of that, we also have the introduction of what was it? The right to turn off, and changed the casual employee definition as well, which I was just going to mention. I don't think it's in these slides, but essentially it used to be as a casual employee was defined as somebody who that worked continuous and systematic on a regular pattern of work with no firm commitment of future employment. And so if you hired a casual employee, they again could be deemed a part-time employee after they worked a continuous pattern of work, which then evidenced that they had a future expectation of work. And so there's been a lot of cases where casual employees brought an unfair dismissal claim, and that has triggered an objection saying, well, they don't have a right to bring an unfair dismissal because they're just a casual. And they found, well, actually, they're not a casual, they're a part-time employee. Because when we looked at the pattern of work, it was a regular systematic pattern, and therefore they had an expectation to work in the business, and therefore they're part-time, and you haven't paid all their statutory entitlements, and then they get an order for having to pay them backwards for all of the unpaid entitlements. Now they've tightened this up even more, where the no firm advance commitment to continuing an indefinite work is the new definition, which means it's going to be much harder to say that someone that works on a regular systematic basis for a continuous period of time is still a casual. And they've also changed the laws last year that says that if you have a casual employee that's working for a regular pattern of work, you have to actually offer them to convert into part-time. And they have a right to convert into part-time under their modern awards. And generally speaking, during maybe the first 6 months or after 6 months every year, you should probably offering them to turn into a part-time employee if they look like a part-time employee. Otherwise, if it's found to be part-time, you're going to get hit with all the past entitlements when you haven't paid them their long service leave, annual leave, public holiday pay, and so on. And then, yeah, they have a specific rules that they're creating for the gig economy and for the road transport, but they haven't actually brought that into effect. Next slide. And one more thing before we jump over to Connor is they've also, last November, they changed the laws under the Australian consumer law that opened up the claims for unfair contract terms, where it says that if a contract is unfair, then you can seek an order for that contract to be struck out and being unenforceable. And generally speaking, annual renewal clauses, fixed term contracts with a penalty for someone to exit early, if you have a different notice period to terminate, so one person only has to give 4 weeks, the other person has to give 3 months. If you have one-way limited liability or one-way indemnity clauses, unbalanced contracts in a standard form contract can be found to be unfair. Now, they've now brought that into employment law as well, where now an employee can bring an application to the Fair Work Commission to find that a particular clause in their employment contract is unfair, such as a restraint of trade clause or a non-solicitation clause or a very broad intellectual property clause. So if you are drafting these clauses, you have to be mindful that the Fair Work Commission, as of next week, is getting the power to strike out those clauses. And I'll pass it back over to Connor.
Thanks, Damon. There's actually, I'm just going to switch the screens over, Damon. There's a few questions. There's some in the, there's one in the general chat by Sarah.
So do we jump in? Well, I'll jump into the Q&A.
Yes.
So if a contractor has their own PTY Ltd company, does this define, or does this make them a contractor? Not necessarily. So unfortunately, it's now very vague in the sense that just because you tell someone, or just because someone creates a company and then contracts to you, does not necessarily mean they're actually a contractor. So for instance, you hire someone as a contractor, but they work 9 to 5 for you, they work from your office, they manage your staff, they're probably going to be deemed an employee. And especially if they're not working anywhere else, and they have to follow all your policies and procedures. And same thing for tax purposes, is that if that PTY Ltd company does 100% of its revenue from the one source, then it can still be deemed an employee for tax purposes, because they want to make sure that the principal that's making the payment is ensuring that the actual founder or the director of that company is paying their own super. So just because your contractor is a PTY Ltd, it doesn't get around these rules. It helps, but doesn't get around. And then the next question is, well, if they are deemed an employee for tax purposes, then would their payments then go towards the payroll tax threshold? I don't know the answer to that, but Tim might, and each state's slightly different. And then the next question is regarding NDIS. A disability support worker is an ABN worker. And if they work the allocated hours, pay at the set rate, no super, no entitlements, they can't delegate to anybody else. Most likely they would be seen as a contractor if they're doing the majority of the work from your business. From a tax perspective, yes. But just because they are an ABN holder, and just because it doesn't necessarily make them a contractor. This is an area of law, for instance, that lawyers study in law school probably for a week of reading, because it's a very complex area. But let's say, for instance, you have an international exchange student that is doing NDIS services for 5 different providers, and they're just taking shifts from random different providers. It doesn't necessarily mean that they're now an employee of you. They could be still deemed a contractor because they're working at various different sites for various different providers, and they choose to be a contractor because they can accept and reject work whenever they feel like it. And maybe their partner and them have their own business, and they're using an ABN for that purpose. So you have to kind of look into the factors. So I wouldn't say 100% that they're a contractor, but it is possible.
All right.
And then the rest are kind of tax related, so we're probably best off to pass that or defer that over to Tim. And then there's something about the transport sector as well, and whether their existing structure is legitimate. So the new changes for the road transport laws are coming in next week, but it's then up to a group to come up with the rules around it. So there's some changes now, but there's more rules that are coming. So I don't know if I can actually answer that. And I'll pass it over to Connor, and then we'll save any other questions till the end.
Cool, thanks, Damon. I'm just going to show quickly for 3 to 5 minutes on how to actually book a consult or book a contract review. Obviously, we're talking about employment agreements and contractor agreements, for example. So one of the first things you'll want to do is actually obviously type in the contractor agreement if you're planning to use a new one. And you can see we've got a few related results. And if you're unsure about which one's the correct one, all the documents do have a bit of a summary and details to what's included. However, if you didn't want to use the live chat connection with the lawyer, this might be a good way to actually utilize the LawPath AI feature and actually ask it, what is the difference between those different contract agreements? And it's going to give a bit of information around obviously the key differences, and throw in a few extra tips around like superannuation, for example, and then just make note of some of the types of clauses to really focus on and be aware of. But if I was to jump into it, and just for the purpose of this webinar, I'm going to go to create the document. I'm actually going to force complete it, so I can take it through the contract review. I will be doing a webinar on Thursday where I'll do a full platform demo. So I'll talk about some more of the features here. But if I go to complete document, it's going to flag that it's incomplete, which is there as a safeguard to make sure you're not sending contracts out to be signed where you're missing key details. But for today, I'm going to force complete it. And then I'm going to, once it's done, immediately ask it to get a review or request consultation. So it's really straightforward, really user friendly. It's going to ask me the area of law. I can go contract review. If you're coming onto us for the first time or you've still not yet booked your first consultation, would actually recommend a discovery call to really hash out your business and get the lawyer to poke for any legal gaps that you're not aware of within the business. Otherwise, for today, I can go through the review. And then here is where I'm going to want to actually outline a brief and outline what kind of advice I'm looking for. I've maybe done a bit of overkill here, and that's deliberate just to give you guys examples of things you can ask. But you might want to, we've talked about avoiding sham contracting, for example, on the webinar. So you might want to check actually, is the person you're hiring, can they be defined as a contractor and not an employee? You might want to actually discuss more detail what they'll be doing for you, so you can really work out the kinks of where they fall within that. And a lot of people would be very popular to have a conversation around protecting their IP from the contractor. That might be in terms of what additional clauses they want to add in or how they tailor the language to protect the business. Or they may want to actually potentially get some accompanying documents like an NDIA or like an assignment of IP, or even getting the contractor to sign potentially a waiver or some workplace policies as well. When you're bringing them on board. And finally, and really, really key as well, make sure before you're signing anything on the dotted line, you are getting clarification on any clauses or provisions you're unsure of. Don't be 99% sure, be 100% sure. So I've included some examples there. Maybe I want to get some advice on the GST and invoicing, or advice around the termination by notice or breach of contract. Or maybe I also want some advice around the language of clauses to add in there. Coming back to kind of a bit about IP, post-contractual restraints, or clauses or provisions that are going to relate to working with competitors or previous clients. And those are just a few examples to name, but a very, very few. And the important thing is about getting a lawyer to help you with tailoring your contract agreement to your specific business requirements. For example, if you're going to contract someone to build code for you, you want a very, very robust IP assignment deed built into the contract. If you're at any kind of early stage ideation, you might want them to sign an NDA before they get started. A really famous real world example, if you guys know it, is literally Mark Zuckerberg and the Winklevoss twins. If anyone knows or seen the Social Network movie or know the story behind that, you'll know exactly what I'm talking about. But a really high profile case of why it's important to get contracts in place and get them tailored. So from there, I could actually add in the document I've used. It is a skippable step. Or if you've got existing contracts, you can actually drag and drop. As long as you have a PDF form, you can drag and drop those files into the console and have those reviewed on call as well. And next. You can choose a selection of our internal lawyers here, or if you're doing it for the first time, I recommend select the best lawyer for me. Because what will happen there is our legal service team will have a read of your brief and make an educated guess who they think is the right fit for you. You can go video or phone call. And then depending on when you want to book, as you can see, we've got availability for tomorrow, generally next day or same working day consultations. And I won't click request consult now, it will take that time. But that's exactly what it is in a nutshell. If you guys want any more topics around platform demos or want a personalized one, you should have an email from me. You can book in a consult there and we can run through some of the additional features. Otherwise, as I mentioned, we will have that Thursday webinar as well, where I'll do essentially the same thing. So I'll just go back to the slides and things over to Tim.
Thanks very much. Let's wait for Connor to mute his thing so we don't get the echo feedback. Fantastic. Good to go. Just before we jump in, I'll just, there are a couple of tax related questions I can answer for you there. Carolyn, certainly in New South Wales, now payroll tax is different state by state, but in New South Wales, yes, if a contractor is deemed an employee for tax purposes, their payments will contribute to the payroll tax threshold. I would suspect it's going to be the same state by state. But of course, you should check with your accountant or lawyer. I believe that was probably the only really tax relevant question there. Poetry, Salim, you've got a vaguely tax related one, but it's more of a legal question. Look, the tax does tend to follow the law these days. We don't have a big discrepancy between the two. I would say certainly the ATO is always nudging you if something is a line ball decision that they want them to be considered an employee. So I would just bear that in mind, but please do seek advice. Now, when we're talking about tax for employment and superannuation questions, I'm sorry to be the bearer of bad news. This is going to be mostly a doom and gloom situation. We're talking compliance, we're talking obligations. I promise though, if you stick with me, I do have a carrot to dangle at the end. My very last slide is some tax opportunities for small businesses in particular. But for the meantime, let's talk about the tough bits. And you guys would all know it if you have employees. There is a lot to do, and we won't dodge away from that. There are huge penalties for wrongdoing when it comes to employment, and there are a lot of positive bonuses on you as an employer to get it right. There are resources to help you. The ATO will lend a hand, but please go to an accountant and get it right up front. This is one of those rare areas where not only can your business really suffer and as a result of being fined for doing the wrong thing, but they can look through those businesses more easily than in normal situations where you as a director have personally done the wrong thing when it comes to employment. There's this wonderful thing called the DPN, or the Director Penalty Notice regime. And I say regime with a deliberate choice of words. You can receive a very aggressive initial letter from the ATO if you've missed your quarterly PAYG, or pay as you go withholding obligations, or if you've paid your super late. Very quickly the ATO can jump down you and basically issue you a notice that says, we're not discussing it, you now personally owe us this money. So they've really flipped the script on you and said, well, you now personally owe it. You convince us otherwise if you want, but the default situation is that you must now pay us everything you owe. Okay, so now I've given you the really scary bit. Why is this? What is the basic obligation on you as an employer? The most important one from the government's perspective is that you must withhold tax on employee salaries. Why is the government so keen to protect that? And the reason is about half of the federal government's tax collection comes through employers withholding tax on salaries. So it's about $270 billion a year. This is money that's constantly coming into the general revenue. It's constantly being spent. If everyone turned around tomorrow from an employer's perspective and stopped paying to the ATO PAYG withholding, it would very, very quickly grind to a halt. Okay, so we've worked out it's important to do it. How do you do it? It's not too much hassle. You should upfront through your business register for PAYG withholding through the ATO, or get your accountant to do it, much easier. You must then get all of your employees to fill out, you would have seen this form a million times, it's called a TFN declaration form, or tax file declaration form. If you've seen this red and pink big boxy thing, that's what you're thinking of. It hasn't really changed in about 15 years. That is where your employee tells you everything relevant. Most importantly, it tells you their tax file number, their name, their address, all pertinent details. If you do not get this form from your employee, you should withhold 47% of their salary from day one. So don't listen to your employee who says, no, I don't need to give it to you. I think that's come up in the questions. I don't need to give you my TFN, or I can't find it. Can you just process this payroll as usual? From day one, you should withhold at 47% until you've got their tax file number. Very, very important. Once you've got that tax file number, your accounting system will really do a lot of the hard yards. If you're on anything modern like MYOB or Xero in the cloud, you will enter this information from that tax file number declaration form Every time you then process a pay run, the ATO will receive all of the relevant information, and your software will tell you how much to immediately pay to your employee and how much to carve out to pay to the ATO. So that's all really taken care of for you, which is why I do thoroughly recommend anyone with employees, please do it through a cloud-based accounting process that is linked into the ATO systems. Make sure you get that information right. There's a couple of boxes there that particularly young employees will often get or will often overlook or perhaps get wrong. There's a box there for HEX help. So anyone that's had the government step in and pay some of their uni fees up front, they will get a big whopping extra tax bill. And if you don't tick that box as an employer, your employee is going to get a very, very upset lodgement when they do their personal tax return, because they're going to owe a lot of tax. So it's really, really important, just in terms of keeping your employees happy, that you make sure you follow their information correctly. Likewise, the tax-free threshold, if you're in an industry where people have lots of casual jobs, if they accidentally tick that tax-free threshold box for all of their jobs, they might work 4 jobs earning $20,000 a year. Fantastic, $80,000 a year, no tax withheld. And when it comes to do their annual tax return, they will be very, very upset. Okay, now what do you have to withhold tax on? It's not every bit of money that you get to your employees, but it is most of it. It's salaries, whether you're permanent or casuals. It is directors' fees for working directors who are personally engaged, as opposed to doing it through a services company, which we do see sometimes. Bonuses and commissions, yes, you should be withholding on that as well. Thank you very much, Colin. Super. Sorry, more doom and gloom. Superannuation is one of these things where, from an employee perspective, it's gotten a lot better. It's gotten a lot easier. From an employer perspective, it's become more of a hassle. Now, superannuation is great. It provides everyone for that lovely, relaxing, retirement that we've all dreamt of, and that the government doesn't want to pay for. So the government doesn't want pensions. It wants you to save for your own retirement through compulsory superannuation. You must pay what's called the superannuation guarantee for all of your employees up to a cap of $30,000 a year. So for high earners, there is a natural limit to that. That superannuation guarantee rate has been creeping up about 0.5% a year for a little while. It used to be 9% for a long time. It's now up at 11.5% since July the 1st, the most recent one. And it's going up another 0.5% next 1 July. And then everyone's going to take a breather. Now, I'm not sure if anyone's noticed this. Do check your employment contracts. Some contracts are quoted ex-GST, and some are excluding super, some are including super. That will depend. That will really change the story of, well, who's going to pay for this extra 0.5% of super? If the contract is excluding super, then that's on you as the employer to fund the extra 0.5%. If it is inclusive of super, you're in luck as an employer, and you can actually reduce your employees' base salary accordingly to keep the package the same. Now, superannuation is tax deductible. So when you're paying for super on behalf of your employees, you get a tax deduction. It reduces your annual tax bill. It's an unusual one in that it's only deductible when it's paid. Now, normally you've got an invoice for one of your business expenses, you pay it in July or August, no problem, you can claim it in June. Not so with super. The most obvious tax planning opportunity that you have in a small business, if you're going to be paying super anyway on July the 14th or the 21st, pay it on June the 25th. Get it in, get it deductible, reduce this year's tax bill. Now, so that 11.5% is payable on what's called ordinary time earnings. So we've invented another acronym to add to the mix in case you're not confused enough. OTEs. OTEs, again, is all of your salaries, as you'd expect. Most directors' fees, but not all. God knows why. Bonuses, whether it's set by expectation, so regular bonuses set by a formula, and regular commissions as well. There are exclusions to that. If you, as an employer, are a particularly generous person and you've given a discretionary bonus that is not directly related to someone's work performance, i.e. you've given everyone $1,000 because you're just a legend, good for you. You don't have to pay super on top of that particular bonus. Now, when I said super has evolved into this positive obligation, it used to very much be the employer's prerogative to choose a super fund when an employee came on board. And you could change that around if you wanted, but if you wanted just to offer one super fund, that was generally fine. We then moved into this idea of super choice, which is where employees could say, I don't want to have your default super fund. I want to bring my own. I'm very happy with the one I've had from my old job. Let me give you 15 bits of information that are often difficult to find, but you do have to then offer them the choice of that super fund. We've gone one step further recently to stapled super. This is where you will come a cropper if you haven't tried it before. Stapled super says, look, we as the government recognise that young employees in particular, low paid employees, will lose a lot of the superannuation that they earn because of fees. Basic account keeping fees will very quickly soak up all of your super if you're a low paid employee. So this positive obligation is now that you as an employer, if your employee doesn't give you details of the super fund, you have to proactively go out there to the ATO and find out if they've already got an account. Now, how to do this is beyond the scope of today, but it is not easy. I'm almost bringing it up now to please implore your employees, do give us a super fund details, or we can help you set one up. Don't go through this process of having to find the stapled super. It is genuinely difficult. Like I said, the ATO takes wages and super obligations very seriously. Do not think of the ATO as a light touch on this. Traditionally, they have been, particularly through COVID on GST and other taxes and income tax, frankly, you could get away with leaning on them for a few weeks while you paid your other bills. Not so. Anything employment related, put it top of the pile. Just like you wouldn't stop paying your employees and expecting them to turn up, don't stop paying the ATO your employment related tax and expect them to stay away from it because they will chase you. You can use things like the Small Business Clearinghouse to simplify your super payments if you're a small employer. It means you do one payment out to this clearinghouse who then spreads it out to your employees for you, as opposed to you having to do 15 different transactions. We might just very quickly pause and just see if there's any questions that have come through. Carolyn's come through with, oh, she already covered it. Fantastic. Thanks, Carolyn. Much appreciated. That was just about the super increase and can it be absorbed? And yes, it depends, depending on how it's in your contract. Is director on salary considered a closely held payee in Xero? Yeah, so that's probably, you're probably referring there to the idea that in your tax return, you have a separate disclosure for when you've paid an associate or a closely held associate. Yes, if you're paying a director a salary, you do have to disclose that in an additional box. What important things do you need to do differently? Not too many. A director on salary is receiving a very similar payment to a salaried employee. There's not much to do there. I think that's it in terms of questions. We might go on to the carrot. Working owners. If you are a shareholder and you are in a business, some of you who are in this situation will be paying you a salary. I'm not here telling you that is the wrong option, but please do know that it is one option and there is a second option that is can be more tax beneficial. We offer an accounting advice plan here at LawPath, and I've got a few of my clients on the webinar today, so it's good to see you guys. The most common question we get on this accounting advice plan is, how do I pay myself? Do I put myself on payroll? Do I just start taking money? Option one, salary is the easiest way to do it. The tax is withheld every time you're paid, it's taken care of. There are no surprises at year end. If that's the way you want to go down, all power to you. If you're looking to get a mortgage or refinance a mortgage, this is probably the way that banks and mortgage brokers really understand the easiest way, so that's great. However, as a working owner, you are exempt from employment minimum wage requirements and withholding tax obligations. You do not have to pay yourself a salary. Okay, but you still want to get some cash out. You still got your lifestyle expenses or just going to Coles to try and buy some essentials. You do have the opportunity to keep taking money We call them drawings in our industry, or dividends, you'll hear them referred to as well. This is the single most lucrative tax planning opportunity that I know of. And I've been doing this for a while. It works, it's perfectly legitimate. It's something that profitable businesses can use to reduce their family group tax bill, because you're not avoiding tax. You are declaring all of the payments out to yourself correctly, but you have an opportunity around year end to say, well, I personally didn't earn that like I would have if I was on a salary. I actually have the opportunity to choose a non-working spouse, perhaps some adult children. If I've paid some of their expenses on their behalf, they can reimburse me with some of this money. You can use what's called a corporate beneficiary, or a bucket company, you might have heard them described as. You can basically reduce your tax bill quite legitimately that way. Not just that, you get what we call a tax holiday. You know, when you're on salary, if you're getting paid on the 15th, you're losing money to the tax office on the 15th of every month. If you're doing it this way, the tax burden can be pushed back almost 2 years down the line. Now, you will pay the tax eventually, but the ATO is paying catch up, and you've had the time value of that money for a little while. When I say check with your accountant here, I mean this generally. You should never go down the path of dividend and drawings structure without it being completely looked across. If your accountant has not brought this up with you before, they are remiss. It is a big planning opportunity. Even if you think they have before, ask them to have another look. At LawPath, that's something that we do as absolutely standard. We make sure that we've thought about the best ways to pay you. Another little bit of icing on the cake. Someone mentioned a question about payroll taxes and state payroll taxes. Salaries are certainly subject to payroll tax. Dividends are not. So that's another little tax saving. If you're already above that payroll tax threshold, well, then that's another 5% or so saved on payroll tax. And that's the end of my slides. Any further questions?
Too easy. Thanks, Tim. We'll cover the Q&A questions shortly. I know people have to hop off now as they'll use this period on their lunch to view the webinar. Obviously, we've highlighted a few changes to be made aware of, especially ahead of next Monday, the 26th. But we'd recommend taking the next logical step in getting advice to your actual business. We talk often about best business practice and making this a priority for it. And you can absolutely go ad hoc and book one-off consultations. However, the most cost-effective approach we have is we've got 20% off on our legal advice quarterly plan if you use this coupon just for the webinar attendees today. The subscription is 100% tax deductible. It's classed as a digital business expense by the ATO. And we will be reaching out to help people claim the offer and get booked in for those first calls. However, you can reach out to us as well directly if you want some help getting set up. Feel free to comment in the web chat or reach out to me via email. And here you can see with our legal advice plan here. In essence, if you've dealt with lawyers before, you'll know firsthand how cost effective it is by comparison. It's a fraction of the cost of the traditional legal system, yet we can still pay you with very senior legal experts and chartered accountants on our accounting advice plan. We've partnered with Amazon and AWS and created one of the world's largest legal AI systems. It's unique to our platform and to Australian law, and essentially there to make your life easier. We've actually found from the Australian Bureau of Statistics, I put the link into it in the web chat, but if you are starting out or you're in that kind of 3-year period, the businesses that actually are with LawPath do have a 25% difference and advantage in their survival rate, which is fantastic. Your success is our success. But don't just hear it from statistics, hear it from the horse's mouth. I've included some client testimonials as there. You can see them on our website. You can see them on our YouTube page. We've got over 30, I think now, where you can see how clients who will have businesses maybe just like yours, how they've utilized LawPath for their legal and accounting services. Obviously, hence why Tim's here. We do have some accounting and tax services as well. We've got LawPath Tax and Advisory. It offers a suite of tax and accounting services, which can also be tailored to the needs of your business. It's just designed to obviously make sure that you manage your financial compliance and obviously optimize tax strategies. So if anyone would like more information on that, you can email Tim directly through the chat or get in touch with us. We'd be happy to run through what we offer as part of that service. But in a nutshell, when it comes to the legal advice, it really is unlimited. It's unlimited documents and the document builder. It's unlimited 30-minute phone consultations with our experienced lawyers, unlimited on-call contract reviews for your contracts you may use on our platform, or also anything external, as long as it's within scope. And as I mentioned earlier, same day and next working day bookings. And it doesn't just have to be around this particular topic. You can discuss hot topics like business structuring, your intellectual property, debt recovery, startup law, commercial property, to name but a few. So this will be expiring by close of business tomorrow. So do get in touch if you want to claim that offer for your business and learn a few other things which will be taking effect from next Monday.